Hello, YouTube. I'm Vince White. I am an employment attorney, and I am answering publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Is that still, can you understand what I'm saying, or do I say it too fast? Oh, yes, and I must ask you to like and subscribe because it helps us to help more people just like you. All right, so here we go. We got a question here from YouTube user Eric Thomas, and Eric Thomas has posed questions to the channel before, and his questions I think are very helpful questions. He asks questions that a lot of people can benefit from, so thank you, Eric. I made a short answering the first part of this question, but I'll read the question into the record right now and answer it in its entirety. Eric asked, "Hey Vince, what's mandatory conciliation, and what should I expect going into conciliation?" All right, so I made a short, which we will link down below, describing what mandatory conciliation is, but mandatory conciliation is basically mandatory mediation. It is going to sit in a place or even just log into a Zoom or a Microsoft meeting or whatever the court's using and work with a mediator and the other side to try and get your case settled. And it might sound strange to you. You might be asking yourself, how can they force me to settle my case? They can't. They can't force you to settle your case. Not really. What they can do is force you, if you want to go forward with your case, in certain situations, they can force you to sit down and talk about settlement. Now, that is not the same as being forced to settle. It's the first thing you should know. You don't have to settle. You don't have to make a deal you don't want to make. There's no way in a non-binding mediation, right? This isn't an arbitrator. It's a mediator. They can't tell you, I decided your case. You're going to get X amount of dollars. Take it. They can't do that. That's not what a mediator's role is. It's not what they do. There's certain very rare situations that are not, like, you'll know. Trust me, you'll know. You'll also be represented by counsel, almost certainly, if you're in a situation where a mediator can, like, make a recommendation that sticks. So, like, don't worry about it. Realistically speaking, 99% of the time, the mediator cannot decide your case. Okay? So, let's just assume you're going to sit in person, but remember all this could be telephonic in the era of post-COVID. And in terms of what to expect, I'm going to talk about what to expect from a bad mediator. I'm going to do it like that because good mediators are magic and they help people and they get people to settle their cases in ways that is mutually disagreeable, right? If you have a really, really good mediator, everyone will leave that mediation, the plaintiff, the defendant, all the attorneys will leave that mediation being like, I'm not happy. And if everyone leaves a mediation not happy, that means no one got an amazing deal and the case was settled for an amount that was fair, generally speaking. That is the mark of a great mediator. Almost no one ever leaves a couple plaintiffs, but it's pretty rare. Like most plaintiffs will leave the mediation like, oh, I don't know if I should have settled that case, right? Now, you can talk all you want about why it's a good idea and you're hedging for risk and, like, it might have been the right thing for you and you didn't want the case to go forward and you didn't want to fight this for 2 more years. There's a lot you can talk about as to why you might settle a case. We have a bunch of videos on this channel as to why you might settle or might not settle, right? But the mark of a good mediator is you leave that mediation being like, I'm not happy, but I don't think they are either. That's how you know you done got mediated. And that mediator, talent, skill, experience, right? Now, we're not going to talk about good mediators because good mediators get things done with finesse and grace and put a smile on absolutely no one's face, right? Like, it's just everyone leaves unhappy, like, as I said. But a bad mediator, which is often what you find in a mandatory conciliation or a mandatory mediation program, a bad mediator is a mediator who will employ tactics that I'm going to talk about at some length here. And you find worse mediators, generally speaking, in mandatory mediation because mandatory mediation has the lower success rate. So, like, super talented mediators, the cream, it rises to the top. And people will throw wads of cash at them, right? I often work with a mediator who mediates armed conflicts between nations, right? He's that good. He's that good. He really, really is. He teaches mediation. He is the mediator of New York, like in many ways. And he is compensated as if all those things are absolutely true, right? And so, he has his own practice and people seek him out and he doesn't have to sign up for some mandatory mediation program through a court or an arbitration or anything like that, right? often what you'll see, these mandatory mediation groups are tied to a court who wants to lighten their caseload. And so they'll go grab some volunteer mediators, or they'll grab some lowly compensated mediators. And they'll say, hey, we're going to force people to come in, and you're going to sit with these people for hours and try to force them to settle their case. And like, you're not going to make a lot of money, but you will get a lot of experience, and maybe someday you'll become a great mediator and make big bucks. There's a lot of attorneys who don't like being attorneys. It's a rough gig, I get it. So they try to become mediators, but generally speaking, mediation's a lot more complex than fighting with people. It's much easier to win a fight than it is to reach a compromise, frankly. So, note to all the would-be mediators out there, it's a tough game. It's a tough and complex game. If you want to get into it, like, go in knowing that. All right, so bad mediators. Here's what's going to happen. They are going to get a big conference room and try to get all the parties in the big conference room. So you're going to have attorneys from the defendants, attorneys from the plaintiffs, the plaintiff, the defendant, at least a representative from the defendant, hopefully someone with some decision-making authority. Like, there's a good chance whoever comes from the defendant will have a certain amount of cash that they can play with to get the case settled. And then later on, they might be like, oh, I've exceeded my authority. I need to call my employer and see if I can go higher. Like, that's a whole interplay that goes on routinely. There might, in some rare cases, be an insurance adjuster who can throw money from an insurance policy towards getting the case settled as well, although often in our field, insurance companies declaim because many of the things that we are litigating are intentional acts. So it's hard in most policies, not all, but in most, it's hard to say, we offer insurance for hate crimes in the workplace. People don't accidentally commit hate crimes, right? Like, it's not like they're intentional. They wake up and they decide, well, I'm still deeply racist, so I'm going to drop some N-words today. Like, that's what they're doing, right? It's not, oops, I've been racist on accident. Like, that's not, the only accident is that what lived in their heart slipped out. They were like, oh, the timing of my racism was poor. Too many witnesses, right? Like, that's the accident. So these are often intentional acts. These are choices. And often insurance companies will be like, thanks for paying your insurance premiums, employer, but we out because you got bad employees, right? And they're just not going to pay. And the employer is not going to have a ton of luck under most policies getting them to pay. But you could have an insurance adjuster there. Certainly, I have seen it on many occasions. And the mediator is going to ask the parties, not the attorneys, to speak often. That's what bad mediators do. And part of what they're doing is they're trying to do two things. One, they're trying to make the defendant feel uncomfortable. Whoever's the representative doesn't really want to talk because at the end of the day, the representative who shows up is probably not the business owner and also probably not the person who did the bad things. So they're there with money to get the case settled, probably not thrilled to be the representative of the company that did the shitty things, right? So that's uncomfortable for them. Then when you look at the plaintiff, who the mediator also will want to speak, mediator's trying to do two things there. First and foremost, he wants to make the plaintiff uncomfortable. He or she, the mediator, wants to make the plaintiff uncomfortable to kind of underscore that litigation and this fight is hard and scary. And even mediation, which is a conciliation process, a process of bringing people together and trying to get them to compromise, is difficult and jarring and hard and emotionally taxing, right? The second thing the mediator is trying to do is trying to make the plaintiff feel that the defendant heard them. This is very disingenuous, of course, because no one who did the bad things is likely at the table. The employer has a representative at the table who's been empowered to make some amount of monetary offer, likely, but you probably don't have the bad actors at the table. So, it's not all that bright that we're like, oh, the plaintiff feels heard by the defendant. Probably not. It's just not a thing. Now, if your attorney's smart, they'll say, hey, yeah, my client's not going to talk today. I'll do the talking. And the mediator will say, that's not how we do things here. And I'll say, yeah, you're not in charge of how we do things. I have to be here. My client has to be here for our case to go forward. That's why it's mandatory. But I did cross that threshold and I'm here. And that's all you fucking get, right? Like, they're not the boss. They're the lowest paid mediator imaginable. They're just there mark the sheet. I'm here, right? And mediation is a beautiful thing, and it's people talking about giving you money, and I have many videos on why you should always mediate. Mediation is a great fact-finding process, even if you don't settle your case, but also you should engage in it in good faith, because often you can get great settlements at mediation. Mediation is incredible. But don't let them put plaintiff in a corner, right? Nobody puts baby in a corner. Like there's no, I'm not referring to plaintiffs as baby. I'm trying to make a joke there based on Dirty Dancing, but I don't want to infantilize plaintiffs. They've been through a lot. So you just don't let the mediator do the things the mediator wants to do. Like your client doesn't have to talk. Your client should not be forced to talk. Unless your client is incredibly outgoing and aggressive and like a great communicator who's not going to feel the interpersonal stress of high stakes litigation. If that's the case, then by all means, let them hold forth. Like that's great. But don't let people pressure your client and force them to speak at a crowded table. It's not valuable. It's not good for your client, and it's not where the money lives. Just don't do it. Then, so that's going to be done. That could take 20 to 40 minutes, whatever. And the mediator is going to say, all right, I've arranged coffee and donuts, or like a little spread. Got some cold cuts, some nibbles in 2 separate conference rooms. And I want to break up the parties and send them each their own conference room. And I'm going to bounce back and forth between these 2 conference rooms. And I'm going to start with the plaintiff. As you go, you get your really bad coffee. You get your charcuterie board or whatever it is. And listen, you always know the quality of the mediator. If they're not feeding the parties, they didn't come to play. Like blood sugar kills more mediation, because people don't eat before they come very often. And then 2 hours in, they're starving and they're like getting hangry. You're not going to settle a case with hangry parties. Like it's not going to happen. And beyond that, they're like, I just want to go. I'm not going to settle. I want to eat. I'm done. I'm out. And the minute they're allowed to end the mandatory mediation, which might, depending on your program, I don't know what the program of mandatory conciliation you're involved with is, could be an hour, could be 2, could be 3, could be half a day. I don't know. I've seen the whole spectrum. So you know instantly if they're not feeding an array of macronutrients to the parties, nothing's getting done. Just complete waste of time. Just nonsense. I've known mediators who are especially shit in this regard, and I have ordered very fine foods for both sides. Like I've just arranged to have it delivered. I've gotten menus and been like, hey, defendant's attorney, we've worked together a couple times. You know, it's been years. We got lunch coming in. It's going to come in from a third party. You don't have to worry. It's not from me. I may not trust me. But here's a restaurant. It's pretty famous. I think you might like it. Here, order everything you and your client want. No limits, please. And then whatever they order, add to it. Just get desserts, get sugars and proteins and fats in them. Make them happy. Make them able to think. Because a thinking person will do the dollars and cents calculations of, I probably ought to settle this case. And it's probably cheaper and better for me to do the right thing today, right? Same thing goes for your client. Don't let your client get strung out and hangry and like rage out and leave. It's not intelligent. Now, I'm going on 14 minutes here. We're still at the hors d'oeuvres. So the mediator is going to come in. A bad mediator is going to come into your room with the plaintiff and say, hey, okay, so I want to hear from the plaintiff. And at this point, I would say as the attorney, yeah, let your client talk to the mediator. But have made sure that you've prepped your client. Because here's exactly what the mediator is going to do. He's going to try to make your client feel heard, which again is something he tried to do with the defendant. He wanted your client to feel heard by the defendant. Now he wants your client to feel heard by the mediator. That's patronizing. That is a tactic that works at low-end mediations like small claims and stuff like that. Here, we're mediating hate crimes in the workplace, sexual assaults. Somebody stripped you of your livelihood and your ability to feed your kids and keep a house because you dared to complain about disparate treatment in the workplace based on any protected class, right? Like we're not playing with warm fuzzies here. We're not, Cindy took my saxophone on the playground and I'm sad. Like that's not what we're doing here. This is serious stuff, and generally speaking, feeling heard is insufficient. So it is patronizing and a little bit silly. It is necessary to some extent. Like the mediator should listen to your client. That's important. But many of them come in with the idea of like, I just need to listen to this person for X amount of time so they feel heard. It's not how human beings work. That's not how mediation works. Like, that's not how any of this works. Like, developing a real understanding of what someone's saying to you takes time and active listening and questioning. It is not easy. So a bad mediator will just sit and be like, tell me everything, right? It's like a bad dude on a date. Just tell me everything. Okay, bro. Okay. And so your client's going to talk a little bit. And then almost no matter what your client says, because we're dealing with a bad mediator's going to be like, okay, I hear you. I understand. But I do hear some flaws in your case. I think you're going to lose. So I think you should settle your case. I actually think you're asking for way too much, and I think you should take way less. I think you're in a bad position here. I think your attorney may have inflated your expectations, and I think you should just take less. I'm sitting there like, my guy, the end is nigh. Like, I'm coming for you. Like, but they do that. They do that routinely. And then here's the secret. They're going to say, okay, you guys talk amongst yourselves. I'm going to go talk to the defendants. And they're going to go across that hallway. They're going to stuff some cannoli in their face. And they're going to tell those defendants that they are in so much trouble. This case looks amazing. They could lose millions. They better get their offer up. And you might say, why? Why would they have said the exact opposite to the plaintiff? Why had they told the plaintiff to take chump change? And then why are they telling the defendants to pay millions of dollars? Because they don't give a rat's booty about anybody involved. They want to settle your case to improve their numbers and stop working. And they don't care if that is for 50 cents or $50 million. They do not care. Like, you will often hear in the elevator defense attorneys and plaintiffs' attorneys, when their clients are not around, exiting together. And like, yeah, mediator tell you, you're going to lose big? Oh, yeah. He said we're going to lose the factory. Yeah. Like we might be foreclosed upon. We could lose so big. And then, you have these conversations, and then the defense attorney's like, so your guy's a liar, huh? I bet the mediator said he'll never prove anything, right? Yeah, that's exactly what he said. He said he can't prove a gosh darn thing, right? I'm trying not to swear. I'm a little worked up because I just, bad mediators do bad things, and they're garbage people. They're just garbage humans. And it's weird because it's a job that's like meant to be really good. Like, sitting down and trying to hammer out a compromise about a really bad thing that happened is a beautiful thing. Fundamentally, like, that's a beautiful thing. And I guess I can't fault them for being incompetent, but I can fault them for some of the like underhanded tricks they try. Right? Like, there's more incompetent people than competent people in the world. That's just how humanity works. In a given job, 60-70% of the people who do the job are just, we'd be better off if they weren't there doing the job. Right? That's just how it works. 30% of people tend to do all the work in any given field. And I don't hold that against a bad mediator. I do hold against them the fact that they have come to this most significant of moments unprepared. They've not developed themselves, their mediation skill set, in a way that will let them do right by someone who has suffered horribly. Horribly. Right? So I'm not making videos about good mediators, because good mediators help people and take care of themselves and do great jobs, and you'll know when they're around, right? They're out there. There's tremendous mediators. But bad mediators, what I would actually say to you, I think the mark of a good plaintiff's counsel and a good defense counsel, if you're at mandatory mediation and if you happen to have a bad mediator, the attorneys might say, hey, we're just going to get together, attorneys, and talk about this. And if the clients agree to that, the mediator might not. And you say to that mediator, you can be in the room, but you can't talk. We're done with you. We're on the clock. We're doing the mandatory thing we got to do because the judge said we got to do mandatory conciliation. And we're here, and we're engaging in the process, but like, enough. Enough of your nonsense, right? And then the attorneys will get together and be like, okay, listen. Let's talk. And defense counsel is going to be like, listen, 5-figure case, no chance I'm going to give you more. Plaintiff's attorney's like, well, that's not going to get it done, and you knew that when you said that. Defense counsel might agree. might not be able to say she or he agrees, but might agree, right? This is where they are today. That's where they are today. That's the authority they have. Doesn't mean they're not going to settle later. Doesn't mean good things can't happen later in the case. Just means today they're at 5 figures. They want to give you 5 figures. And you know that you and your client are not interested in 5 figures. And the client calls the shots. Like the plaintiff's like going to say yes or no. And the defense side, the employer calls the shots. It's not like the attorney's like getting to do whatever she or he wants. They have a client who gives them authority to give you money to settle the case. And they might tell that client, listen, I need 300 grand to get this done. The client might say, I'm here in 20. I'm here in 20 grand. That defense attorney then has to show up to mediation with 20 grand in her pocket. That's all she can give. That's her direction. And she knows there's no conceivable way that any intelligent plaintiff or plaintiff's attorney will take that 20 grand on this case. But that's the day she's got to have because she's required to go to mediation and her client is dumb. That happens all the time. And it doesn't make sense to rage at defense counsel when they show up with no money. Now, if they're being belligerent about it, there's things they can do which will make them distasteful to me, but I'm not going to fault them for their client's decisions anymore. I think they should fault me, right? If I have a case that I know is worth, I don't know, we'll call it 300 grand again. And my client's like, I don't want to go with a demand under $70 trillion. Okay, well, there's no damages calculation that could ever be created to support that demand. Also, I'm not positive, but there might not be that much money in the world. Like, these are the conversations you have, right? There probably is $70 trillion. I don't know. But you can, like, talk to your client endlessly, and your client just might say to you, I don't care about the calculation. I need to demand this much. I saw it in a movie, or I saw it, a worker won this in blah, blah, blah. Okay, well, they didn't collect it. Like, it's not how this industry works. There's a damage calculation, like, there's realities to the industry, right? Sometimes you gotta go in and you just gotta say, all right, here's the demand. It is what it is. And then, the mediator and the defense counsel are gonna be like, how do you calculate that? I refuse to answer questions about my calculation. And everyone just looks at you like, okay, so it's not something you can support with facts. Okay, right? And that's the gig. Clients are the shot callers. They're in charge. You can give them all the advice you want, but that's what you enter the mediation with. I will say, even a bad mediator can be really valuable to sit down and be like, hey, so you went with this demand and your attorney's refusing to tell us how you calculated it. Can you tell me how you calculated it? Because I have a lot of the formulas for how damages are calculated. Side note, there's a playlist on this channel with a lot of videos about how to calculate your damages. Really valuable if you're trying to get ready for mediation. But plaintiff, like, your attorney won't answer how you got to $70 trillion. Will you tell me? And the plaintiff will say something, and the mediator will say, yeah, but you earn 18 grand a year. So you would have to work infinity years. Just about. Not literally, but just about. To get $70 trillion. And, like, your emotional damage, you're not treating. And the things that happened to you, they were wrong. They were bad. There's no physical touching. There was no physical threats. You didn't have any physical symptoms of anxiety. Like, in terms of emotional damages, not the top tier of valuation or seriousness in terms of the emotional damages. So do you see what I see, plaintiff, that your number has no anchor in reality? And that's something even the worst mediator can do. Like, if they're brave enough to just have that conversation and be there for that conversation, let the plaintiff lose her or his mind on them, that's really valuable. And it's one of the things that's valuable about mediation. Mediation, you should go. It's going to be people talking about giving you money. You can learn a lot about the other side's perspective on the case. You can kind of, to some extent, anchor them to some number that they can't really go down from. Videos on this. But also there's a process of like, hey, you know that people outside of you, plaintiff, will have input on this number. Like, you can say any number you want, but when you sell a car, you don't think about how much you want. You think about how much it's worth, right? The question isn't, oh boy, how much money would I like to have when you sell a car? The question is, how much do you think I can get for this car? And those are two very different questions, because one is just a statement of desire, and the other is anchored in fact. You might not be correct, but you're using data and information to calculate a number as to what you think you can get for this car you're trying to sell. And if you are trying to settle a case, you are in fact also going to have to think about, well, if I look at the facts and if I look at how damages are calculated, and if I look at the reality situation, what can I actually get for this case? And also, how do I adjust for risk if I go to trial, right? Like, that's valuable. We have a lot of videos in that. I'm going way too far. I'm at 26 minutes. Listen, like and subscribe. I hope this was helpful. If it was helpful, you know, with the liking and the subscribing. Also, I've been told recently that I should return to my catchphrase, which is, everybody works. Not everybody wins. Take care, everybody.